The law of self-defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Hey folks, welcome to our ongoing coverage of the Minnesota murder trial of Derek Chauvin over the in-custody death of George Floyd. I am Attorney Andrew Branca for Law of Self-Defense. Well, today the prosecution presented 3 of its final witnesses as the state closes in on the end of its case in chief. I'll get to those witnesses in a moment, but I don't want to bury the lead, so here it is. At the end of court today, Judge Cahill informed the jury that they should expect testimony to end this week, meaning including the defense case in chief, and that they should arrive Monday ready for deliberations to begin, which means, for the jurors, bring an overnight bag because once deliberations begin, sequestration of the jury begins. Indeed, testimony may end prior to this Friday. The judge informed the jury that the only reason he's not going to plan on closing arguments happening on Friday is right after closing, they need to be sequestered, and he doesn't want to have to send the jury into sequestration for the weekend. The obvious implication, given that the state hasn't yet even quite completed its own case in chief, is that the defense case in chief is expected to be no more than 3 days in duration. That's in contrast to roughly 11 or 12 days of the state's case in chief. So we're almost at the end of this rodeo, folks. I expect daily content on this trial from Law of Self-Defense through the end of this week. Then Monday, I suppose, we'll start our traditional verdict watch process. And of course, we'll share the final verdict or mistrial if there is no verdict news with you all as soon as we can get it ourselves. So with that out of the way, let's jump into today's witnesses. If the headline to today's post didn't give it away, 2 of today's witnesses were among the most annoying I've seen in this trial, and indeed among the most annoying I've seen anywhere, really. Those were Dr. Jonathan Rich, a cardiologist out of Chicago, and Professor Seth Stouten, a law professor and purported use of force policy and standards expert out of, I think it was North Carolina. Now, let me state up front that when I say these 2 were the most annoying, that's my own subjective perception of these 2, and perhaps reasonable people, including the jury, would disagree with my assessment. That's why, of course, we include the video of their actual testimony embedded in the text version of this content so you can view it and make your own call on those kinds of matters. So we'll start with Dr. Jonathan Rich, cardiologist. So his testimony as a cardiologist struck me as, frankly, entirely cumulative of previous testimony already heard earlier in the trial. And if you don't understand the term cumulative as a legal term of art, you can read our midday post today that covers that in some detail to get a solid grasp of that. The general idea, however, is that at some point, essentially identical testimony from numerous sources tends to have a biasing effect on the jury, becomes just piling on, and this is generally discouraged by the courts. They prefer you get your best witness, or maybe 2, on whatever the issue or fact they're recounting is, use them, and then move on. Don't use a half dozen, or in this trial, even more, witnesses to effectively provide mere slight variations on the same testimony. And today, we really didn't learn anything from the state's paid expert witness, Dr. Rich, that we hadn't heard from the other state's paid expert witnesses. As far as the state's paid expert witnesses are concerned, the sole cause of the death of George Floyd was the subdual neck restraint and the positional asphyxia to which he was subjected by the officers involved in his arrest. I mean, at this point, we get the state's position. The only real difference was that Rich presented his view of the same conclusion using the wide-eyed manner and the tone of voice an adult reading a "I've got 2 daddies" sexual orientation guidance manual to elementary school children would use. And again, that's arguably unquestionably my subjective view. Maybe as far as the jury was concerned, Dr. Rich completely knocked her socks off. He certainly had the CV, the resume of a world-class cardiologist moving up in the world. Indeed, I had the definite impression that Dr. Rich's next move up was intended to be entering the world of trial expert witness testimony because once again, in Dr. Rich, we have a state expert witness who has never before been an expert witness in court. First time out in a case of this high profile. And he did it for free. at least until he actually showed up to testify in court, at which point he's getting paid $1,200 a day for all his prior effort, an effort other states' expert witnesses have indicated exceeded 100 hours of work. It was free. Again, in the context of Dr. Rich, he said what the state needed him to say. George Floyd died from cardiopulmonary arrest caused by low oxygen levels. Those were induced by the prone restraint and positional asphyxiation that he was subjected to. That's his conclusion. Of course, we're once again dealing with a physician making detailed clinical findings based on other people's reports and smartphone, body camera, and surveillance video without ever having actually seen or examined the patient in any way. Further, like all the previous similarly minded physicians who similarly lacked direct examination of Floyd, Rich very much presented the appearance of someone who'd watched the most awful-looking parts of the Floyd bystander video, drawn an immediate conclusion, and then identified an opportunity for professional advancement as an expert witness by working his way backwards from that conclusion to a speculative medical rationale consistent with where they once again wanted to end up with their conclusion. They didn't start with the evidence and then arrive at a conclusion from there. They started with the conclusion and then cherry-picked the evidence they wanted. Now, I won't spend much time on his direct testimony, as the quote above basically captures it in its entirety. Floyd's death was the neck restraint and positional asphyxia, period. And like some other earlier state expert witnesses, Rich claimed to be able to identify on video the precise moment that Floyd went into cardiopulmonary event right there on the street in front of Cup Foods. And by the way, that's in contrast to the other state expert witnesses. For example, Dr. Baker, the only physician in all of this who actually laid hands on Floyd's body for post-mortem examination. He testified, Dr. Baker, that he believed Floyd was alive when he was put into the ambulance and didn't die until he reached the hospital. Now, that sounds to you like conflicting states' expert witnesses fostering reasonable doubt about Floyd's manner of death? Welcome to the club. Dr. Rich also had some views of cardiovascular physiology and function that struck me as rather odd. Now, granted, I'm no cardiologist. Still, very odd. For example, George Floyd's enlarged heart, technically cardiomegalopathy driven by hypertension of the sort that ultimately leads to congestive heart failure and death, well, that was not the sign of a compromised physiology, a compromised cardiovascular system. That was actually a strength, literally. You see, that was just Floyd's heart getting stronger. Just like if you go to the gym and lift weights, it was just getting stronger by pumping blood at a higher pressure. In other words, cardiomegalopathy of the sort that ultimately kills you, it's not a glitch. It's a feature. I kid you not. That was his testimony. Rich also participated eagerly in the prosecution's preferred means of medical deception of the jury, which is to conflate narrowly defined medical terms of art with much broader commonplace terms for physical ailments or causes of death, and then deny the presence of the narrow term to suggest, but not actually, deny the presence of the broader common term. For example, did Floyd have a heart attack, a broad term? The answer is why no. There was no sign of ischemic occlusion in the coronary arteries. And narrow means of a heart dying. Of course, that doesn't mean that Floyd didn't die as a result of his heart failing, because perhaps it received an insufficient supply of oxygen to causes largely independent of Chauvin's knee, such as 90% occlusion of the coronary arteries, fentanyl overdose, methamphetamine use, a lifetime of drug abuse generally, pathological hypertension, COVID, and the decision to fight 4 officers in an effort to avoid lawful arrest. All that the denial of an ischemic event means is that the precise manner of Floyd's heart stopping was not an abruptly formed clot resulting from the rupture of atherosclerotic plaques in his coronary arteries. And Dr. Rich was happy to detail to us and the jury that no such plaque rupture was reported to have occurred. It merely means that the precise manner of Floyd's death stopping was not an abruptly formed clot resulting from the rupture of atherosclerotic plaques in his coronary arteries, and Dr. Rich was happy to detail for us that, and of course for the jury, that no such plaque rupture was reported in the autopsy to have occurred. Now, for anyone who doesn't understand the distinction, however, And who on the jury would? This kind of conflation works. It sounds as if the annoying and patronizing doctor said that Floyd's health couldn't have pooped the bed for reasons other than Chauvin's knee, which was, of course, the state's goal in calling Rich to the witness stand and having him engage in this kind of conflation of medical terminology. Dr. Rich also had remarkably succinct and definite notions on whether anything than Chauvin's knee or prone position could have killed Floyd. Fentanyl overdose? Nope. Meth? Nope. Why not? Well, Floyd's a drug user. He probably had a high tolerance, the doctor said. Well, was there any mention of Floyd being clean for a considerable period of time until a couple of weeks prior to his death, as recounted in testimony by his co-addict lady friend, suggesting a much reduced tolerance relative to a chronic user? Nope. Dr. Rich also happily participated in another common rhetorical sleight of hand used repeatedly by the prosecution on the issue of whether Floyd could have overdosed. The state asks Rich if Floyd's death had the typical appearance of someone suffering solely from a fentanyl overdose, the sleepiness, for example, or the difficulty speaking clearly or responding properly to others. Nope, answers Dr. Rich, I saw nothing like that in all the videos I watched. Well, setting aside the testimony that the jury may never hear about Floyd's passengers in his SUV being unable to awaken him to the point that they called others to come pick them up from the intersection of Chicago and 38th, the question entirely ignores the broader context of Floyd's actual circumstances. He was not only on a high dose of fentanyl. What's a fentanyl overdose look like when, for example, it's combined with meth, a powerful stimulant, when it's combined with acute ingestion of fentanyl, followed immediately by a 10-minute physical confrontation with 4 police officers? I expect that kind of fentanyl overdose begins to look a lot more like what we observed Floyd experiencing. Rich also informed the jury that I counted the minutes that Floyd was pulseless without CPR as part of the state's argument that delayed care by Chauvin and the other officers is what killed Floyd. In fact, the period of time from which the officers determined that they can't find a pulse to the arrival of the paramedics that the officers knew to be en route on a per Code 3 lights and sirens is about 90 seconds, not minutes. None of that matters, however, because the good Dr. Rich informs the jury that had Floyd not been subject to the neck compression and subdual restraint to which he'd been subject for 9 minutes and 29 seconds, he'd still be alive today. In follow-up, the state asked if it was true that nobody, not a healthy person on the face of the earth, could have survived that 9 minutes and 29 seconds. And if you didn't guess, the direct was done by Prosecutor Blackwell here. Nobody on the face of the earth could have survived that 9 minutes and 29 seconds of neck compression and subdual restraint. Defense counsel Nelson objected to this question, and Judge Cahill sustained the objection. The state asked the question a second time in slightly modified form. Defense objected again. Objection sustained again. But the bottom line from Dr. Rich's testimony was that nothing else about Floyd could possibly have killed him but for the conduct of the officers. 90% occlusion of coronary arteries? Nope. Fentanyl overdose? Nope. Pathological hypertension? Nope. Do other people die of those things? Yes. But not Floyd? Nope. Could Floyd have had a heart attack? No, Dr. Rich said. He had no chest pain. Left unasked by Nelson, however, might 11 nanograms per milliliter of the powerful pain reliever fentanyl have allowed for a painless heart attack without chest pain? Alternatively, might the pain-inducing effects of the pills Floyd had taken, remember, essentially identical pills had sent him to the ER previously in similar excruciating pain, could that whole body pain have simply masked the chest pain of a heart attack? Here again, Dr. Rich made a remarkable characterization of heart disease for a cardiologist. Remember, having a pathologically enlarged heart was a feature, not a glitch? Well, apparently having 90% occluded coronary arteries was also a feature, not a glitch. Because, he explained, when the coronary arteries get sufficiently occluded, the heart would begin to grow collateral blood vessels to make up for the constricted blood flow of the primary coronary arteries that were occluded. Well, indeed, it's actually less risky, he said, to have a higher degree of coronary artery blockage that fostered collateral blood vessel formation than it was to have a lower degree of coronary artery blockage. I mean, who knew? As wide-eyed and dramatic as Dr. Rich was on direct questioning by the state, I have to say he was rather tremulous and shaking on cross-examination, and frankly, that's not unusual for someone serving as an expert witness in a prominent trial for the first time. After all, you only get prepared by your side. You're only practicing, really, your side. Nelson also spent some time with Dr. Rich on cross-examination discussing Floyd's paraganglioma, which has the small tumor in the hip region, has a theoretical capability to dump a massive bolus of adrenaline into the body and cause a cardiac arrest. This line of questioning never seemed to go anywhere, really, and I'm undecided about whether Nelson is doing just enough here to establish some foundation for a medical expert witness he plans bringing into court for the defense case in chief. As his last question for Dr. Rich, Nelson asked if it were possible, after the lungs stopped, for respiration to continue. In other words, after the process of lungs breathing, could respiration continue? This seemed an odd question to me and highly unlikely physiologically. I expected the doctor to say no, but it turns out that's why I'm a small-town lawyer and not a doctor. According to Dr. Rich, it is indeed possible for there to be a few extra breaths after the physiological drivers of respiration have given up the ghost, although he wasn't certain of the mechanism behind that physiological effect. It would later turn out one reason this question was important was that it appears the officers believed Floyd to still be breathing after the point where some state witnesses claimed that it identified his point of death from their observation of videos. So after the cross-examination, there was a brief redirect and recross of Rich, but nothing much of substance. So all the videos of the Rich direct questioning, cross-examination, redirect, and recross are, of course, embedded in the text version of today's content. Now, the next witness for the state was Philonese Floyd. My apologies to Mr. Floyd if I've mispronounced his first name. It's not familiar to me. I won't spend much time on his testimony because the brother this was George Floyd's brother. He has no firsthand knowledge about the events surrounding Floyd's death. He isn't positioned to offer an expert opinion, for sure, so he can't offer testimony that would be relevant to the legal merits of the prosecution or defense in this case. So why have him testify at all? Well, most states would not allow such testimony at this point in a trial, precisely because it doesn't go to the legal merits of the case. If anything, it's prejudicial to the defendant. It's an odd feature of Minnesota law, however, that they allow what they call spark of life evidence into the prosecution's case in chief. This is basically testimony about how wonderful the deceased person was, how much his family loved him, and so forth. Now, in most states, such testimony is permitted, but only in the sentencing phase of the trial. In other words, after guilt has been determined, a guilty verdict, the court can take such testimony into account after that point for purposes of sentencing. Or if the jury's involved in sentencing, which happens in some states, the jury can take it into account. Normally, however, such testimony is deemed not relevant to determining guilt or not guilt in the first place. So normally, first you have to get to a verdict. Only then would you have this kind of testimony. Now, before I embed the spark of life testimony below, I do want to make clear that I'm addressing it only lightly here because of its lack of relevance to the merits of the case, and what I do is legal commentary and analysis. It's not because it's inherently lacking in merit. Whatever one might think of George Floyd, and he certainly appeared to have a well-checkered history, I've no doubt his family loved him and miss him terribly. And folks, that's as real as anything ever is. So that said, here's that testimony, that spark of life testimony. It's solely direct questioning because the defense wisely declined to conduct cross-examination. The last state witness of the day, and amongst the two most annoying of the whole trial, as far as I'm concerned, was Professor Seth Stouten. He's a law professor who had briefly, less than 5 years, served as a police officer in Florida and is now into the use of force expert witness game. And at least in this case, the game pays well. He testified that he's been paid about $25,000 for his expertise by state prosecutors for about 140 hours worth of work on this case. Now, in my professional opinion, whatever you may think of Professor Stouten, that beats doing the work for free as some other state witnesses have done. I'm told by others who have looked online that Stouten appears to be among the more rabid, defund the police, reform the racist police murderers activists out there. I make it a practice, however, to limit my trial commentary and analysis to what I actually see in court. and nothing much like that appeared in court, with one modest exception I'll point out. So I'll leave it to the reader, to their own efforts in developing an internet-based understanding of Professor Stouten, if that's of interest. Now, as has now grown familiar, Stouten was there to say the magic words to the prosecutors in this trial, and he didn't fail to deliver the goods. He purports to apply a 4-step analytical framework to determine if the use of force in question was consistent with what would be expected of a reasonable police officer acting consistent with national, generally accepted police standards. Interestingly, Stouten examines this question, or at least in this case, with zero inquiry into the standards, practices, and policies of the actual department of the officer in question, the department that actually trained him and would hold him to those standards. That officer may have followed his own department's policies to the letter, but if he didn't meet the national, generally accepted police standards as defined by Professor Stouten, his use of force was unreasonable and worthy of criminal conviction and perhaps life in prison. The 4-step analytical framework followed by Professor Stouten consists of the following components. Step 1, look at the relevant facts and circumstances as they would have been viewed by a reasonable officer on the scene. Step 2, consider the degree of threat offered by the suspect. Step 3, consider the foreseeable effects of the force used by the officer. Step 4, apply generally acceptable national police standards to determine ultimate reasonableness. Now, in my modest opinion, this is not a wildly unreasonable analytical framework for evaluating the reasonableness of an officer's use of force. I would say that I certainly wouldn't limit step 2 to a degree of explicit threat offered by a suspect. I think police officers have to continually consider possible threat, the possibility having to be reasonably inferred from the circumstances. It can't be an irrational or speculative possibility. I'll come back to more of that in a moment. But like with any model, analytical model, the obvious caveat has to be GIGO, meaning garbage in, garbage out. And that is, of course, precisely what Professor Stouten did in this case to arrive at the conclusion the prosecution sought. To begin with, in step 1, where he considers the facts and circumstances as would have been viewed by a reasonable officer on the scene, remarkably enough, the facts and circumstances most consistent with Floyd being the victim of a racist police murder were prominent in Stouten's inputs to his algorithm. Conversely, when asked by the defense on cross-examination about facts and circumstances that are incontrovertibly in evidence from other states' testimony, Stouten's memory proved substantially defective and in need of constant refreshing, and the patronizing tone he'd adopted throughout direct questioning by the state turned on cross-examination into stuttering, uhs, can you repeat the question, and I don't understand what you're asking me. Again, the prosecution returned to old tricks from prior state's witnesses, even where those tricks hadn't worked out for them the first time. You'll recall that one prior state witness was presented with 3 bullet points from the MPD use of force policy addressing justified use of force, and that these were presented as the entirety of the use of force justification analysis. And to refresh your recollection, those bullet points were: 1, you consider the severity of the crime at issue; 2, you consider whether the suspect posed an immediate threat; and 3, you consider whether the suspect was actively resisting. Now, on cross-examination of that prior witness earlier in the trial, Nelson had quickly gotten them to concede that while these were indeed 3 factors to consider in use of force decisions, they were representative of all the relevant factors to consider, not the entirety of all the relevant factors. Maybe the state thought Nelson would forget how he'd gutted this deception the first time it had come up in trial, but he hadn't forgotten, and quickly had Stouten here making the same concession on the witness stand today on cross-examination. Stouten also played fast and loose with the concepts of risk and threat. Specifically, according to him, a threat was an active use of force by a suspect, and only that active use of force by the suspect could justify an active use of force by the officer. A mere prospect of force, however, according to Stouten, however likely it might be based on actual experience and facts, was merely a risk of force, not a threat of force, and a mere risk of force could not justify any degree of force by the officer. This is, of course, inane on its face, and to make it appear not obviously absurd, even Stouten had to make concessions that gutted the core principle that he just espoused. For example, what about passive resistors, people who laid across the street in protest? They were not threatening anybody with imminent harm, so were police prohibited from using any degree of force upon them, even the mere force necessary to carry them from the street? No, that was okay, said Stouten, because these people were quote-unquote threatening force in some amorphous manner that didn't actually involve a physical use of force against anybody. In particular, Stouten said, once a suspect is handcuffed, he no longer represents any degree of threat to anybody, and therefore the police should be using no force against him, whatever. I mean, I guess that means once the suspect is cuffed, the police are just supposed to ask, can you meet us at the police station? We'll call you an Uber. See you there. And of course, we've had prior testimony from state's witnesses where handcuffed suspects had killed officers. Indeed, Stouten at one point took all this to truly ridiculous lengths by suggesting that instead of trying to fight Floyd into the backseat of the squad car and attempting his lawful arrest, once Floyd made them aware of his anxiety and claustrophobia, the officers instead should have offered to allow Floyd to ride in the front seat of the squad car. Presumably, one of the two officers would take the back seat behind the barrier while Floyd rode up front with his partner. In the real world, of course, the police consider not only active threats currently taking place against themselves or others, but also the reasonably foreseeable prospects for continued or renewed threats. A compliant driver pulled over for speeding is rarely subject to any use of force by the police officer involved, and I would know I have more than my fair share of speeding tickets. I blame the motorcycle for that, by the way. Now, once a suspect has been physically non-compliant or even violent with an officer, however, a reasonable officer will position himself to be prepared for continuing or renewed non-compliance or violence. It would be profoundly unreasonable to require or expect officers to pretend that a just violent suspect, now offering to be compliant, to treat them the same way they treat a suspect who has been compliant throughout the whole interaction with the officer. But not according to Professor Stouten. Those two people should be treated the same way. Now, as poorly thought out as his analytical approach to police use of force might be, however, Professor Stouten had no doubt whatever about the conclusion it brought him to. What killed Floyd, according to Professor Stouten, state's paid expert witness? Can you guess? Sure enough, neck compression and positional asphyxia induced by subdual restraint. Who'd have guessed it? Also, like every other state witness testifying on these questions, it was very clear that Stouten had started from the conclusion that Floyd's death was a result of the Chauvin's use of force. After all, police racist murder, right? And then worked his way back from there to build out a rationale that would, shocking enough, bring him right back to where he started with his conclusion. Indeed, in this case, whereas I'm somewhat largely speculating that other states' witnesses followed this build your rationale from the conclusion you want approach, we actually have evidence consistent with that approach in the case of Professor Stouten. This came in the form of an op-ed that Stouten wrote with two others, both co-authors on his latest book, so same worldview on these issues, in which they concluded that Floyd's death was the result of Chauvin's racist police murder, neck restraint, and positional asphyxia. And how do we know about this Washington Post op-ed? Well, defense counsel Nelson was kind enough to ask Stouten about it on cross-examination. What's notable about this conclusion of Stouten and his colleagues was that the op-ed was written in a 4-day period between the date of Floyd's death and when it was published in the Washington Post, and before Stouten had seen anything other than the bystander video. No medical reports, no autopsy report, no toxicology results, no hours of body cam footage or surveillance camera footage, no 40,000 pages of investigative reports and MPD policy and training materials, because who needs all that when you already know what happened from the bystander video? Incidentally, folks, pro tip, one of the most common and effective means of impeaching the credibility of a purported expert witness is to be able to demonstrate that they had approached the question and issue not with an unbiased, impartial, and open mind, but instead with having decided the question beforehand, which is exactly what Professor Stouten did in this case. Now, the state was also eager to use Stouten's testimony to undercut the defense narrative that the hostile and threatening mob killed Floyd, or at least substantially contributed to Floyd's death, by complicating the ability of the officers and responding paramedics to do their jobs. Remember, the mob was perceived as sufficiently threatening by the paramedics that they elected to do a load and scoot rather than treat Floyd on site, despite how much of a medical emergency they knew he was in. One consequence of that, by the way, was that it took much longer than would otherwise have been the case for the backing fire department responders to meet up with the ambulance they didn't know had moved 3 long blocks away from that intersection. So to undercut the scary mob line of narrative from the defense, Prosecutor Schleider would show the witness and jury an image of the bystanders on the sidewalk, a photograph, still image, typically early in the event when there were only 4 or 5 there passively watching Floyd's arrest, maybe another photo from a few minutes later showing 6 or 7 unobjectionable bystanders filming with their phones. At no time did Schleider show video of the angry, shouting mob hurling insults and threats of imminent physical violence at the officers, because of course not. Now, did the apparently passive observers in the still photos shown by Schleider qualify as something that should have distracted the officers from their attention owed to the suspect in their custody and care? Not if they are reasonable officers, answers Stouten. The prosecution also shared images of several selected points in the restraint of Floyd. Now, these were generally not still photos, but close to it. These were little 10-second clips of different portions of the event, such that an entire context was difficult or impossible to draw. The state was really compelled in that position because showing the whole video again was suggested by Judge Cahill to be cumulative, so they didn't want to do that. Was Floyd a threat here, the prosecutor asked, picking one 10-second clip. Nope. Was he here? Nope. Was he here? Nope. And because a suspect being a threat, in the odd way threat was defined by Stouten, was a required element of a finding of justified use of force by Stouten's algorithm, the way he applied it to these facts and conclusions that he favored, there was never a point after Floyd was on his knees after fighting himself out of the squad car that the officers had any privilege to use any force on him again, whatever. After all, Stouten said, and I'm not making this up, he said, hey, Floyd even said thank you after fighting his way out of the squad car. So the officers knew that any resistance he'd ever intended to offer them was certainly over now. The state spent about 90 minutes on direct questioning of Stouten, but it was all of the same tenor as I've just described, so I'll leave my detailed commentary at that. Of course, I do provide the video of his direct questioning for your viewing pleasure embedded in the text version of today's content. Now, on cross-examination by Nelson, we suddenly saw the patronizing Stouten on direct suddenly turned forgetful, stupid, apparently unable to comprehend simple and direct questions, where he wasn't, that is, providing answers wildly beyond the scope of the question actually asked. The way cross is supposed to work is the defense counsel, or whoever's on cross-examination, it could be the state during the defense case in chief, but whoever's asking the question on cross-examination asks a very specific question, and ideally they get a yes or no answer back. Stouten liked to give a ambiguous answer back and then a long, lengthy explanation that was supposed to arrive at the conclusion he wanted you to have, regardless of what the meritorious answer to the question actually asked might be. Mostly, by the way, Nelson allowed Stouten to run on in this manner in his answers. Only once or twice did Nelson exercise his privilege to cut off Staunton's self-offered additional information by correctly objecting that it was non-responsive to his actual question. Every time Nelson did object in this manner, his objection was sustained by Judge Cahill. And when he was sustained, you could almost see Stouten working his mouth as if choking on a chicken bone. He so desperately wanted to get out that non-responsive information to the jury. I'm not sure why Nelson didn't rightfully object more frequently on grounds of non-responsiveness. He seems generally disinclined to raise legitimate objections throughout this trial, passing up many opportunities to do so. And indeed, he objects far less often than does the prosecution, whose objections are most often overruled by Judge Cahill, by the way. One of the reasons I perceive Judge Cahill as being pretty much middle of the road, unlike, for example, Deborah Nelson in the George Zimmerman trial. Now, there are possible strategic reasons for adopting this kind of laid-back stance on objections. And if Nelson hits a home run while presenting his own, apparently relatively brief, case in chief, then arguably this quiet approach might well have contributed to an acquittal. If he doesn't hit it out of the park, he probably will end up looking like he passed up a lot of opportunities to object, and did so for no really good reason. I guess time will tell. Well, there wasn't much of anything productive to gain from rigorous cross-examination of Professor Staunton, the suddenly stupid and easily confused Staunton, on cross-examination. So while Nelson touched on the most important points of contention, he didn't waste energy trying to get argumentative with a clearly hostile state witness, a prudent approach we've seen with similar state witnesses earlier in the case. Now, at one point, I thought Nelson was going to turn cross-examination into a ground fight of his own after Stouten repeatedly was unable to recall important and well-known facts around the Floyd event, facts caught repeatedly on various body cameras and by other means. You don't remember this? Nelson asked. Nope. You don't remember that? Nope. Yet you've testified you spent 140 hours of your time reviewing the materials of this case, including the videos, informing your expert opinion? Yeah. But Nelson ultimately moved on to the next questions about which Staunton had only vague recollection of the facts. Alternatively, Staunton claimed an interpretation of events entirely inconsistent with that of probably every other human who has seen the video, certainly different than mine. Nelson asked him, do you agree that when Chauvin arrived on scene, he immediately observed Lane and King struggling with Floyd at the door to their patrol car? Staunton, well, I wouldn't call that struggling, really. You kidding me? They were fighting him into the squad car. How about that moment when Floyd was laid prone and immediately kicked his legs out at Lane, prompting the officers to consider going to the hobble restraint? Stouten's reply was, no, that's not the way I saw it. I saw Lane grab Floyd's legs and straighten them to flip Floyd into the racist police murder prone subdual position. Racist police murder being my own words, of course, but you get the tone. And of course, that's what Staunton would say. It certainly looked like a kick to me. There was a portion of cross-examination here where I felt Nelson really dropped the ball, and it was on the question of proportionality of police use of force. Nelson proposed that it was reasonable for an officer to use greater force than was being offered in resistance by the suspect. Staunton pushed back on the use of the greater force as the controlling concept here. What if the suspect is running in flight, for example? What's greater force in that context? Running faster? I found that a fairly effective pushback on the notion of this greater force concept, because I also happen to think it's not a very effective way of framing this issue. A more productive way of framing the issue, I think, is that the officer is allowed to use whatever degree of force is reasonably required to compel compliance in the non-deadly force context or to preserve innocent life in the deadly force context. In both contexts, however, the officer's not permitted to use any more force than necessary to compel compliance or preserve life. So, to Staunton's mocking hypothetical of a fleeing suspect, the force that can be used in the absence of a deadly force threat that would justify deadly force by the officer would be whatever non-deadly force would be required to compel compliance, stop the flight, but no more than that. So that could be a taser, or it could be a full body tackle, or it could be a large fishing net, who cares? But that would be the framework I would apply to that analysis, not a greater force framework, but an as much force as required, but no more than that. And I'd have liked it if Nelson had used that framework in his own questioning on this issue. In the context of Floyd, the officers would have been privileged to use whatever force was required to first secure Floyd's compliance with arrest, and second, once it was suspected that Floyd was in genuine medical distress and the EMS call bumped up to a code 3, to secure Floyd's continued presence on site for treatment by the paramedics. There is, of course, more to Nelson's cross-examination here, but I think you get the idea. Of course, the video of that cross-examination of Staunton is embedded in the text version of today's content. There's also a very, very short redirect of Staunton, which is also embedded in today's content. And that's about it for tonight, folks. Don't forget to join us again on Tuesday morning, right around 9:30 a.m. Central Time, as we once again start providing live blogging of the day's court proceedings, followed by our usual end-of-day wrap-up analysis and commentary in the evening. Also, anyone interested in a free podcast version of our daily legal commentary and analysis of the Chauvin trial can access the Law Self-Defense News Q&A podcast available on most every podcast platform, including Pandora, iHeart, Spotify, Apple, Google. You can even just get an RSS feed for your favorite podcast player. You can get all those links or any of them at lawofselfdefense.com/free podcast. And thanks as always to both Legal Insurrection and CCW Safe for the support that makes my coverage of this case possible. All right, folks, until next time, I am Attorney Andrew Branca for Law of Self-Defense. Stay safe.